Hello, everyone. Good evening and welcome to day 2 of BusinessPalooza. I have a little helper today. Luna, she's actually well known on my Instagram lives because she doesn't like to listen to me speaking and she wants to join all lives and webinars as well. So she's going to be here watching with me. Say hello on the chat. I always encourage you guys to say the name of your business, what do you do, drop your Instagram handle, drop your LinkedIn URL so we can connect with you. I'm just going to leave another minute for people to connect and we can get started shortly. I am super excited for today's presentation. We're going to talk to James about business contracts. We know that business contracts are super relevant and sometimes we don't have the budget or the time to go through it with a lawyer. And James is super kind to share his time today and tell us 10 things you should look into a business contract if you don't have that budget right now to spend, although you should always try to have the lawyer looking for that. And we also have Darryl and Tia that later they're going to be talking about financial strategies for your business to help you grow your business and minimize taxes. So really relevant topics, super excited. So please say hello again in the comments. I can see a couple hellos here. Really looking forward as well. As a reminder, tomorrow is a holiday in Canada, so we don't have any more presentations this week. But next week, we have presentations on Monday, which will actually be myself. I'm going to be talking about marketing. For who don't know me yet, my name is Julia Fauci. I am a business coach and marketing consultant, and I'm hosting this event with all these amazing guests. I'm very honored to have all of you here. So on Monday, I'm going to be sharing a little bit more about marketing strategies and how you can create a strong online presence for your business. And the same day, I'm going to have Maria and Brandon from Ridley Film, and they're going to be talking about video content ideas that you can use for your business. Then we have another presentation on Wednesday with 2 more guests. We're going to talk about branding, like branding beyond your logo. So it's not just having your logo, but everything else that you do for your business. And we're going to have Jessica, who's an interior designer, talking about the perfect setup for your home office. And lastly, on Thursday, it's going to be a wrap, our last day. Luna is getting comfy here. The last day, it's going to be Thursday. We're going to talk about website platforms. So if you're wondering which platform to use, WordPress, Wix, Squarespace, Shopify, there's just so many options. Monette is going to share with us what are the pros and cons of each, so you can choose wisely. And Teresa is going to be sharing about cybersecurity. So lots still going on with BusinessPalooza. And yeah, I think that's a good start. Can see people chiming in. So I'm going to start with James tonight. As I mentioned, he's going to be talking about business contracts, and I'll let him introduce himself and Macushlaw, the firm that he works at. So welcome, James.
Thank you, Julia. I appreciate the introduction. Thank you for putting all this together. It's great to see people in the marketplace packaging this and making it so accessible, and really honored to be selected to have the opportunity to speak. And obviously, thank you to everyone who's in attendance tonight. Hope we're able to get you some useful tips here to help you in this process. We understand how difficult it can be with legalese, the difficulty of getting up to speed on contractual language, and that really difficult balance at the beginning of starting a business of risk mitigation and expense. It's not an easy balance to strike early on in business. So I'm going to talk a little bit about our business and then do a little bit of housekeeping, and then we'll get into the tips themselves. And one of the things I wanted to stop and talk about is the name. It's the first question we get from most people about our business. So macushlaw, no W, it's an Irish Gaelic term that literally translates to pulse of my heart. It's used in Ireland as a term of endearment. So it's a little cheeky, a little bit strange. and it's a nod to some of my history, but it really embodies what we're trying to do in the legal industry. So bringing a bit of humanity, a bit of uniqueness and accessibility into the industry that really also attaches to formality and excellence and quality of service, but we want to make it a little bit more accessible and human. And some people know this, but our logo at the top corner there, it's a tilde, but that's actually the bottoms of Iusticia's scale. So Lady Iusticia is a symbol in the legal industry, and one of the cups is flipped over as sort of a nod to, we want to honor the traditions in this industry, but also maybe drive some change and turn the industry on its head a little bit. So that's a bit about our logo and what we're about. I just wanted to touch on a few of the things that our firm does differently. This isn't very different now, especially post-COVID, but we are digital by default. More and more firms are going this way. And the big benefit to the client is we have a small office footprint. We don't have a big box in the sky with expensive art on the walls. We don't have fancy suits. We are trying to cut out things that we don't believe contribute to the value of the service that we're providing. We don't need those things. We don't need to charge the client for those things in order to deliver a good quality service. So we're on the street in Gastown when we are in the office. We're in a little lawyer office share here, and that lets us get our standard rates down quite a bit vis-a-vis our competitors. So we're approachable. We've got beards and ponytails and tattoos, and we want our people to be people, and getting rid of what a lot of people call the marble foyer and the legal industry. We want to speak to our clients in a way that they understand, not in legalese or trying to intimidate our clients with the knowledge that we have. We want to use our knowledge to benefit our clients. So we're a small team, 3 lawyers, a paralegal, and a Chihuahua named Tequila, who keeps very close guard on the office. And we're not just aspirational in our goals. We really are different by design. We have terms in our constating documents, terms in our lawyer engagements, and in our terms of legal service that are fundamentally different than other firms. And so what the main difference is sort of focus around time and community contribution. So traditional firms driven by the billable hour, of course, billable targets, and a top-down pyramidal traditional professional services structure. We don't have billable targets. We have non-billable targets. We try not to use the billable hour wherever possible. It's not always possible, but we try and use fixed, predictable rates because we believe that drives innovation, whereas the billable hour, sometimes inefficiency is the profit driver. So we want to drive innovation. We want to be able to stimulate lawyers to think through how to provide a service in less time that's the same quality. We want to make sure that motivation is ingrained in our firm structure. And then the other side is the giving to the community aspect. I mentioned that we have non-billable targets, and we publish a benefit report every year that sort of talks about the benefits that we provide to our community through our operation. And a few of those components are the non-billable target, but also tiered rates. So we offer different rates for different types of clients depending on socioeconomic status, whether they affiliate with a subsection of the Canadian public that suffered significant socioeconomic inequity, or organizations that serve those sections of our population, or otherwise, contribute through their operations more than just seeking profit. So that's a little bit about us. We have quite a few different practice areas. My main area is corporate commercial and real estate, and I have a bit of a sort of a sub specialty or expertise in Indigenous lands work. So we work with nations or organizations that are dealing with nations that are doing lands related work. Lots more information on our website if you want to see about what we do. Okay, so housekeeping. Everyone's probably rolling their eyes. We do this at the beginning of phone calls, the beginning of presentations. It's unfortunately a necessary part of giving legal information. In order for us to give advice that you can rely on and sue us for, we need to enter into a contract, and we need to know who you are. That's not possible, so it's important to understand what we're doing. This presentation is not a substitute for a lawyer. It's not legal advice, but it is legal information. Another piece here is that context is king and the law is complicated. We can't imagine every potential material part of a contract review without knowing what it is that the parties are doing and what the contract says. And so this is an incomplete and an uncomprehensive list of things to look for, but we do hope it's practical and helpful, and believe that it will truly assist you in mitigating key areas of risk when entering into contracts. So if you're in doubt, or you're a company director, it's a particularly large contract with a particularly large amount of risk, always recommend you seek legal advice. And it doesn't need to cost an arm and a leg. Contract reviews can be done in a cost-effective way, and contracts can be lightly touched up to significant effect. So don't be afraid of high fees. Be afraid of bad lawyers. Another housekeeping item, it's important when we are talking about tips for review to understand why it is that we enter into contracts in the first place. So clarity is very important. There's often not a meeting of the minds in terms of what you want to agree on unless it's clearly stated in writing. Having a written agreement helps mitigate risk of confusion, risk of claims, risk of disputes. If you do get into a dispute, it also reduces the cost of litigation and simplifies those disputes. And it's also a rules book for your relationship, so it can be really helpful. Hey, what do you think about this? What does the contract say? It's a good reference for your relationship. And why do we review them? You want to make sure that it reflects the business terms that you've discussed with your business partner, your contracting partner. You want to ensure that you're complying with the terms. You need to know them in order to comply. And you also want to be able to ensure compliance by the party that you're contracting with. It's important to conduct due diligence. So the law will only protect you so much if you haven't taken steps to protect yourself. So it's important to undertake basic investigations about your contracting party to benefit from the full extent of the law. It can help you prevent fraud. We'll get into that a little bit more in the tips themselves. And contracts are a bit of a zero-sum game. Sometimes if you increase a party's protection, that can actually render the other party in a position that's worse than they would have been without a contract. So there is a duality in contracts that they can both increase and decrease risk to a party. So it's important to review and understand the ways that they do. When should I review contracts? Timing is everything. Make sure that you review and agree to the terms and formalize the relationship after you've had a chance to negotiate and review. You want to know what the terms are, but that's not just before execution. Contracts can be formed orally through conduct. So the best test is make sure that you agree on the terms of the contract before any value is exchanged. And for services providers, that's typically payment or provision of services. Either of those things you should postpone until after you agree to the terms for a number of reasons. But one of the key reasons is that amending agreements has a host of issues that come with it. Fresh consideration is required, and amendments may not be binding. And there is an intervening period where you may not know what the terms of your arrangement are. despite the fact that you've entered into one. So housekeeping out of the way, let's get into the tips. This is what you came for. So number one, it seems a bit trite, but who are you entering into a contract with? You want to identify the parties and confirm that they exist. And that's both for yourself. If you have a company, you don't want to enter into the contract as an individual. You want to make sure that your party is on there to benefit from liability protection. Likewise, you want to make sure that who you're entering into a contract is the actual party and is a party that can actually contract. Not all business vehicles can enter into a contract. Individuals, companies, societies, these are legal entities. They can absolutely enter into contracts, but partnerships, sole proprietorships, unincorporated associations, or joint ventures cannot. They're not distinct legal entities. They're either manners of conducting business or collections of legal entities. So how do you do this? How do you identify the parties and confirm they exist? Step one, ask the other party. Who are you? Do you operate out of a company or as an individual? Do you have a sole proprietorship? Sometimes there's a bit of education you have to do here with a contracting party, because a lot of people don't know that their sole proprietorship is not a distinct legal entity. But have a discussion. It's a great starting point. Step two is request and search. So no matter who it is you're dealing with on the other side, if you're contracting with an individual or they represent a company, get their ID. You want to make sure that they are who they say they are, that they exist, that they have an identification, and that they can actually act for or instruct on behalf of the company that you're engaging with. It's not foolproof. IDs can be faked, but it's usually a good starting point. Entity-wise, there are different forums through which you can identify companies. We're just talking about BC and federal. Each province has its own registry. Your law firm can certainly do this for you, and most firms will be reasonable with price. They'll charge you what the fees were, and either won't charge you for the time or just a small amount to go and pull the searches. But if you're entering into contracts quite frequently, you might go and sign up for a BC Online account. It's only $8.50 to pull documents. It's free to search. And once you get the documents, you can see whether the company has been dissolved. That's one of the key issues, that if a company doesn't make annual filings year over year, the registrar can actually dissolve the company. And you don't want to enter into a contract with a company that doesn't exist anymore. But $8.50 to pull the documents. You can see if they exist. You can also see who the directors are, and you get an address for service. It's a similar process for federal companies, except it's free and it's instantaneous. You just log on there. Don't need to log in or anything. You can go to that website and search the company. And just a last note, where the parties are really important is the first page and the last page. First page should set out who the parties to the contract are, and the last page is where they bind themselves, the signature pages. So make sure the parties are spelled correctly and identified correctly in both places. Hot tip number two, review the business terms. Also, it seems a bit obvious, but not everyone understands that pre-contractual discussions typically fall away once you sign the contract. So they are, it's common that you'll negotiate by email, over the phone, you'll be taking notes, but those discussions are typically not binding. So it's important to make sure that you review the contract and make sure that what you think you've agreed to is actually reflected in the agreement. So a question to ask yourself is, does this contract reflect what I believe the deal to be based on our discussions to date? Very important. Number three, we're going through some of the low-hanging fruit here, often forgotten, but very important. So address blanks, brackets, and capitalized terms. Contracts, especially template contracts, if someone is working from something that their lawyer prepared with notes and sort of used for a number of different clients, it'll be full of these things. So watch for the blanks, the little underscore text. You can control F those. And you can also control F entities and brackets that are meant to signify portions of the contract that have optionality or some type of a consideration you have to make in order to finalize the contract. Make sure that those are dealt with. And if there is a trigger that you need to turn your mind to something and make a decision, make a consideration, make sure you're going through each of those. Capitalized terms. Lawyers get trolled for this all the time. Like, we do it in emails, we do it in letters, and often for comedic effect in our Christmas cards and stuff like that. But capitalized terms are very important for clarity and consistency interpretation of contracts. They can, capitalizing or not capitalizing in a contract can be significant impacts on the cost of litigation if you have a dispute. So ensure that your the capitalized terms are used consistently, and that they're actually defined and that they're actually used. It's another thing that you can control F your way through a contract. So spot those defined terms and control F and scroll through the contract and make sure that that's the case. Number 4, ensure the agreement term is sensible. It's just a part business, part legal concern. The term really has to match up with your business goals. So there's a number of different types: month to month, fixed, indefinite, and the definition of term, like a month or a year or a quarter, can change depending on the qualifying term. So does it say calendar year, fiscal year, or is it a year from the date of the contract or the commencement date? Small differences can make a big difference in what it means. So make sure it aligns with what you believe to be the case. Likewise, renewal. Smaller companies that are providing services at a discount rate to get and retain clients, they may want at the end of the year to be able to renegotiate terms. So a 1 year or 6 month term to prove yourself to the client, that may make business sense. But for a company that's got a large amount of revenue coming from particular clients, you may want something with a longer term, an automatic renewal, because you're going out and expending resources on hiring staff or marketing expenses or what have you, and you rely on that certainty and making your business work. So again, questions to ask yourself: does the term work based on what services you're providing? Does it align with your business goals? And can I perform my obligations on the stated timelines? And diarize key dates. I'm sure everyone running a business has G Suite or Outlook or something like that. BF it, put it in your calendar. Make sure you have reminders to, if you need to give written notice to renew the contract, give yourself padding to talk to your business partner, to go to your board and get permission to either renew or not renew, or direction on whether to do one or the other. Diarizing is key. Number 5, ensure that the termination rights and consequences are sensible. So there are 2 main types of termination clauses. There's convenience termination, which is at will, so for any reason, which are not available at common law. Common law only provides, and to be honest, a difficult to understand termination right upon default by the other party. Certain things have to occur in order for that to be available to you as a contracting party, and it's often disputed. So convenience rights, if you want it, put it in the contract. And likewise, default. What constitutes an event of default? How long of a period of non-payment is going to constitute an event of default? Does bankruptcy constitute an event of default? These are items that, if you're looking at the common law, it won't be clear. There's a lot of room for alternate interpretations of the facts, but there are a number of ways to phrase these default clauses. But make sure that it makes sense for what you're doing. And the effect of termination is a knock-on from that. People getting into contracts organizations getting into contracts aren't thinking about what happens when the wheels come off. That's what the doom and gloom lawyers are supposed to think about. So we often see contracts that have incomplete termination clauses and rarely see effective termination clauses. But that's an important one. What happens when a contract is terminated? Does the consequences of termination vary between a termination for convenience and a termination for default? And that becomes particularly relevant to service providers when considering, should my fees all be payable if the party I'm contracting with has a material default under the contract? What services are due and within what timelines if there's a termination? And again, does that vary between convenience and default? So questions to ask yourself: do I want a convenience termination right? Do I want the other party to have one? It's rare that they're one way. So often you have to think, if I get one, they get one. Does that work for me? Are there any actions which would be expressly stated as a default? Bankruptcy is a good one, but failure to provide information that's material to me meeting my timelines, that you need this work or this deliverable done by. How long of a payment grace period should the contract permit? How long after a payment is due should you have to rectify that non-payment before someone can terminate the contract? How long should a party have to fix a breach? So that would be a non-financial covenant. You have 30 days. What if the breach isn't reasonably capable of being addressed within 30 days? Should that lead to a termination right? And should any services or fees be due after termination? And again, diarise dates. So if you're in the midst of a discussion around or the process of notifying the other party that you're terminating, and there are dates that are relevant to remedying a breach or remedying non-payment, make sure that you note that notice has been sent or received and when you need to follow up or when you need to respond by. Outlook and Google Calendar are your friends here. Number 6, ensure that the representations and warranties are sensible. So we're going to start getting into some more legalese here, but I'm going to try and keep it simple and leave you with practical tips at each of these points. But what are representations and warranties? Key question to understanding whether they're sensible. Reps and warranties, or RWs, are a statement of fact upon which the other party may rely. So a great example is one company represents and warrants to another company that their employees have the necessary skill, experience, and expertise to provide the services. It's not often given in services contracts, but it is nice to have if you're the one that's receiving the services. Is it just wasted words? Is this just lawyers trying to increase the amount of billings that they get out of you for contract drafting? In my opinion, no. They're helpful because generally it's easier to establish a breach of contract, or in this case, a breach of representation and warranty, than other causes of action, like negligence. Negligence cases are very costly. Expert evidence is required. They're long, difficult, expensive claims to bring. Whereas party said this, turned out that Joe didn't have his forklift operator license. That's a clear breach of this representation and warranty. Therefore, I'm owed damages to this extent. It's a lot clearer of a cause of action, a lot cheaper to litigate, more cost effective to litigate a breach of contract than other causes of action. Basic RWs that you want to have in your contract: capacity and authority to enter the contract. Really important. Does the person who's signing it actually have the authority to sign on behalf of the company? Another is entering into an agreement, or this agreement is not a breach of law or some other obligation. Sometimes parties may not be permitted to enter into a contract because of some sort of intellectual property issue or a restriction by a regulatory body or something else. And it's a very common RW to have in a contract to get protection for this. There are a number of other specific RWs that you can get. This presentation isn't the right forum to sort of go into detail about each of this, but or each of the potential additional RWs. But one useful question, I think, for if you're thinking about adding additional ones in, is what facts do I want the other party to confirm before I sign the agreement? Is it important that I know that they have IP rights that are sufficient to perform the services, or other similar examples? Just take a moment to think about, is there anything I need? I need a confirmation of fact about before I sign. Okay, number 7. Ensure that key covenants are in the agreement. So again, legalese, what are covenants? Covenants are more or less a promise to do or not do something. They are typically really the meat and potatoes of a contract, what it is that you are entering into a contract for. They're fundamental to the bargain. There are all types of subsidiary or related but not fundamental covenants that you'll see in contracts. But just a few examples. For a services agreement, again, a company will pay another company X amount of fees on a certain date. Company will provide the deliverables to another company on or before a certain date. Or one company will respond to another company's inquiries in a timely manner. So this is really typical in services agreements, the exchange of fees for service, purchase of goods for service. Those really key covenants, just make sure that they're drafted. And a point about drafting, we're down in the questions to ask yourself portion of this slide. Is the obligated party and the act or omission clearly stated? We see passive language a lot in contracts, especially that are drafted by non-lawyers. And passive language is where the actor, the act, and the recipient are not clearly defined. So a good example of passive language is payment will be made. Who makes the payment? How will it be made? To whom? So the second part of that verse is in that first bullet under questions to ask yourself is XYZ Co. will pay the fees to ABC Co. on January 1, 2022. That's active language. There's lots of great resources on the web about this, but covenants can be rendered almost useless if they're not drafted with active language. Is the recipient of the promise clear? Not every covenant will have a recipient, but if it's important that some act be done or not done to another party, make sure that that's put in there. And what do I need from the opposing party in order for me to be able to fulfill my obligations? So the third example given on this slide is a great example of this. So if I'm promising to do something on a certain timeline and the other party isn't under an obligation to help me fulfill that, and my performance is reliant on help that needs to be given by the other party, I'm in a really tough spot because I can't enforce a term against the other party because they don't owe me any covenant under the agreement to participate or give me a hand in me meeting my obligations. And it's difficult to argue reading in contractual terms. It's quite a high bar that you have to meet in order to do so. Okay, you're going to hate me for 8. We have a few types of clauses to get into. This is really tricky stuff to distill into simple, practical tips. So we're going to skip through some of this stuff, but I've sort of set up the slides. I think we're going to be circulating them afterwards. Or at least the video will be available afterwards. So you may have to come back and take a look at this again afterwards, but I've sort of set things up to get to a practical point. We're just going to have to sort of jump through some of it a bit quickly to stay on time. So I'm going to go through a few different key types of liability allocation clauses. So an indemnification, what is an indemnity? We have practice resources where we've got 300 pages written on this type of contractual clause, but more or less it's a promise to make a contractual party whole for losses that they suffer. And typically that's losses that are suffered vis-a-vis a third party. So example of an indemnification is I breach a contract, and because I breach the contract, you can't meet some other obligation to a third party. That third party sues you, but I've agreed in the contract to indemnify you for any losses that you suffer because I breached the contract. So if you get sued and it's by a third party, I would have to cover the costs. If I'm the indemnifying party, I would have to cover the costs that you suffer as the indemnified party resulting from the claim brought by the third party. So there's a number of components to the clauses. I don't want to spend too much time breaking down each individual portion, but I've color coded everything so you can come back and take a look later. But there are key components, and how certain components are drafted narrowly or more broadly, those can significantly change the protection that an indemnified party receives or the risk that an indemnifying party is exposed to. So the practical tip is seek balance. Most indemnifications are mutual and should be mutual, or there should be a degree of mutuality to them. So if you're entering into a commercial agreement, you should both be indemnifying each other for acts that could lead to losses, or leave it out. But what you want to look at is mirror language between the two indemnification clauses, where each component is drafted in a very similar way for each party. There is an asymmetry to parties being in a contract together. Some types of contracting parties may benefit more or less at a starting point than the other party to the contract from an indemnification clause. So it's not perfect, but it's a good crutch to lean on. Just make sure that they're mutual, that you're giving each other the same protection. If you're reviewing a contract and the indemnification is against you, which would mean that you as the contracting party, you or your company, owes an indemnification. You are the one indemnifying the other party to the contract. What you want to do is limit certain parts of the contract with different language. So really quick example, so limit the Nexus clause. The Nexus clause is the green text. The green text here is caused by, arising from, or otherwise relating to. If you can limit that to directly caused by, and then indemnity is yours to bear, you're reducing your potential risk. So I've just kind of given you a little color-coded formula to try and give you a few easy ways to assess these indemnification clauses and put them to work for you, or at least limit their potential risk increase to you or your business. One of the important ones, I'll skip through 3 of them, but to exclude losses contributed to by the other party. Not all indemnification clauses will have this language, but the highlighted text in green, if it's your indemnity, it's useful to just tuck this language in at the end, which is saying that, sure, I'll make you whole, but I'm not going to make you whole for things that were your responsibility. It's a really reasonable ask. It's very unlikely to cause the other party to balk, and it's a reasonable compromise. I promise to make you whole for things that are truly my fault, not for the things that are your fault. So just a couple quick comments on this. If you have questions, this is a bit of a complicated one. If you have questions about it, feel free to email me afterwards. I'll have my contact information on the last slide. But we are offering free 15-minute consults right now. So feel free to check those out afterwards. Moving on to exclusions. So again, these are complicated terms. There are a number of different ways that they can be drafted, but the hot tip or the practical tip is more often than not, it's helpful for both parties to include a consequential damages clause. They should go both ways. Similar issues with asymmetry where the risk of losses are typically higher to the person that's acquiring a product or a service than they are to the person that's providing the service or the product. But consequential damages clauses can reduce the amount of claims that are brought against or claimed against a party by limiting what someone can claim just to direct losses. So it can be really helpful for keeping people reasonable in the dispute resolution process. You're not going to have people throwing out $250,000 claims when it's a $20,000 contract on the basis that, well, you lied to me, that's aggravated damages. You said this about my girlfriend, and that's punitive damages. It can help to keep everybody reasonable and in the same arena during those disputes. So it's worth including. That's the hot tip. And there's a draft provision there that you should get legal advice, but you can touch up and throw into your contract. So another breed of liability allocation clauses is a liability limitation. And stay with me. We're almost through the really dense legalese stuff. These clauses are more or less a limitation on the aggregate or maximum liability that one party can owe to another. So it caps your potential risk under a contract. That's what all this all caps lettering does. It's a weird thing. There's a custom with disclaimers of warranties and liability limitations to do all caps because they feel like that helps it draw parties' attention to the fact that there is a cap on liabilities. But I just feel like it makes it harder to read. I don't know. Lawyers are weird, man. But the key thing here is to what limit can you get away with? We've seen big companies that are in really high demand get away with as low as 25% of the value of a contract as their maximum liability. It's really rare. It's the big infrastructure companies of the world. Not likely going to get away with that as an accountant or a lawyer or a designer or another type of service provider. Market would be more in the 50 to 150% range. So that's one way to cap the liability is a percentage of contract value or a percentage of amount paid over a period of time under the contract. But it makes it also a little bit more simple using a percentage cap because you don't have to change it for each contract. Whereas the other method is with a specific dollar value, but depending on your line of work, you may have $1 million contract and you may have a $10,000 contract, and that dollar value won't make sense in the context of both contracts if it's the same. So unless you're getting away with 2% of contract value. One thing to just flag is that professional statutes can limit the effectiveness of these clauses. So Legal Professions Act is a great example where we have a liability limitation in our agreement, but that doesn't mean that we're going to be able to enforce it in court. Court may read it down or may void the entire clause. So if you're a professional services provider, you don't need to spend a ton of time noodling around the exact language on this clause because it may be that it's struck in any event. So last one, insurance clauses. These clauses obligate a party to obtain certain types of insurance certain types of coverage amounts, and different types of claims bases. So the risk with these is that, again, it's easier to sue on breach of contract than for other claims. And so you may have an insurer that's subrogated for a party that you're contracting with for a loss that you contributed to, and they're going to come after you for breach of contract. So it's really important, the key nugget here, it's really important to make sure that if you're subject to insurance obligations under a contract, like having a minimum of 5 million commercial general liability insurance, it's important to have that coverage or negotiate a reduction to the amount of coverage that you can, that you currently have or you can afford. So insurance rates are through the roof. I think we're all feeling that right now. The rates are up significantly over the last few years. Take these terms, send them to your insurer, make sure that they confirm that you actually have this coverage. Because if they get that wrong, then you can sue them. If they're your insurer, gives you a bit of coverage there, but also they're best placed to tell you whether you have the coverage and what it would cost to get it. And then you can always go back to the party that you're negotiating with and say, listen, rates are way up. We can't afford this. Can we reduce the CGL from 5 mil to 2 mil? Everyone's feeling it right now with insurance premiums up, the COVID stress. You might have some success going back and negotiating a reduction or a change to those obligations, but you need to make sure that you can fulfill them. And again, diarize any action items. So sometimes you'll be obligated to provide a binder of insurance to a party that you're contracting with by 30 days after the contract is entered into. Make sure you put those in your calendar and that you comply with those terms. Okay, we're out of the really heavy stuff. Sorry about that. Had to be a lawyer for a couple slides. So boilerplate, not so boilerplate. What are boilerplate clauses? I missed an S there. Boilerplate clauses are miscellaneous, standard, interpretive, or other basic contractual terms. You'll typically see them near the beginning of a contract, near the end of the contract, or a bit of both. I've never liked when lawyers draft in both places. Keep all that stuff in one place, in my opinion. But that's where it'll normally be located. And some examples that you're probably used to seeing if you review contracts from time to time, entire agreement clauses. So that will say this agreement constitutes the entire agreement between all of the parties. And that's relevant to that comment I made earlier about pre-contractual negotiations don't frequently form part of the contract. That clause operates along with a common law rule called the parallel evidence rule to strike all of those previous negotiations. Notice terms, really important to pay attention to, especially if you're in a dispute. But a lot of parties are choosing to include email delivery of notice now because it's convenient. And that can bring the cost of litigation down as well. Little thing like that, making sure that you can serve each other notice by email can save you hundreds and hundreds of dollars in suit. Attornment, that's another one. If you're dealing with a client in Prince George, but you're based in Vancouver, your lawyers are based in Vancouver, you want to make sure that you're able to bring any claim in Vancouver. So there's a number of terms in boilerplate that they do actually have quite a bit of impact. You'll get better at understanding the impact that they have the more contracts that you see. But these are a few examples. I don't have time to go through every single one and give you some thoughts, but two really key points. Review them. Sometimes people tuck material covenants or terms into the boilerplates, not necessarily intentionally to try and deceive you, but more often because of lazy drafting by lawyers. they were too lazy to figure out what other provision that term should go into. So read it, make sure that there's nothing tucked in or hidden in that boilerplate language. Arbitration is another one. There's benefits and drawbacks to agreeing to mandatory arbitration, but arbitration tends to be cheaper and faster than going to court. The main trade-off there is that you lose the ability to, expose or subject the party that you're dealing with to public scrutiny by filing a claim. If something really bad happens, sometimes that can be a great motivator for settlement. The threat of the issue and the facts that lead to the cause of action that you have coming to light. And there are reporters that every day go down to the courts and pour through every single new application to see if there's anything newsworthy in there. So it can be a major motivator. So just be aware of that trade-off with arbitration clauses. And it's usually something that is dealt with in the boilerplate section. Okay, last one. Man, I feel like I've talked a lot tonight. Hot tip number 10, formalize the agreement. This can be done in a number of different ways. The best way, the easiest way is to sign it. Digital signatures are fine now, so you don't have to get together in the same place to formalize an agreement. And even if you're actually printing and signing, counterpart clauses, another boilerplate clause that lets you have two separate signature pages that are signed in ink. You can combine them. That's a binding agreement. You just want to circulate an email that lets everybody know this is the final version. So you have some record that those signature pages have been applied or attached to that agreement. Best way to do it, execute the agreement. Do that last. Make sure that you've negotiated, you've gotten through everything, all the revisions that you want to see. All that's done before you apply your signature and send it to the other party. There are other forms of acceptance. I just want to touch really quickly on ClickWrap. We've actually been doing a lot of those with clients recently. It's something that we do where you fill out a form and all the information that's required to be able to enter into the contract and customize it is collected in a form. And then by clicking I accept, you receive a copy. You have a certain number of days to reject the terms. Otherwise, you're bound by those terms. If you're a service provider, and it's something that Monette does a lot of, she actually helped us do that for our own company. But it can be a huge administrative time saver. It's a bit of cost and time to set it all up. But if you're dealing with high volume of clients and you want to simplify the admin process to get them signed on to your terms, that can be a really great way of doing it. There's a few things you have to do, and one of them, we just went through an entire presentation on reviewing contracts, is making sure that the contract that people are agreeing to is balanced and fair. Reduces the potential of people coming back and negotiating with you and having to pull it, amend it, and then do the traditional signature page exchange to enter into a contract. That's another way, and more service providers are opting into that. And if you're having to enter into an agreement in that way, just be aware that that you may be bound if you click. So read the acceptance terms in the contract to understand whether you have a time period to reject the terms, to walk away, or other steps are required in order for you not to be bound. Usually they'll have catch-all language in there that says that you accept the terms, but if you, even if we don't hear from you saying that you accept them by email, or you give us notice that you don't accept the terms, but you continue to work with us, that you would be bound by these terms. So something to watch out for. Anyways, I hope that was helpful. I went really fast, covered a lot of subjects. Hopefully there'll be enough info here if you review it again that might make sense a little bit more through another review. It was really great to have the opportunity to talk to you about this. get in touch. Our info is on the screen. And thank you again, Julia, for putting this together and inviting me to participate. It's great to be here.
Thank you so much, James. I'm going to remove your screen now. So it's going to be me and you on the screen if you want to come back.
Perfect.
Thank you so much. This kind of took me back to business school when I had business law classes, and I never thought I was going to need that in my life. I always thought I was going to be in the corporate world. I never thought I was going to be an entrepreneur and have my own business. And now I kind of regret not paying as close of attention to those classes. But like, yeah. Thank you so much. And I also love that there's so much shallow content in the internet when you see like top 10 tips for whatever. And we just read like some very shallow things, and you just really dove deep into those, like packed with content. I'm going to need to rewatch to catch everything that you said. And I'm just very grateful that you shared all of this with us. Thank you.
It's my pleasure.
If you guys have any questions, I did make room for people to ask questions before. I think most people may be like me, like blown away. I don't even know what to ask. If they want to chat with you, James, like what's the process to work with you typically? Like you mentioned a 15-minute consultation, and then you would kind of see what the person needs to give the terms. Like, how is that?
Yeah, this is a new initiative for us, but one of the things we're finding is that a lot of clients are afraid to talk to a lawyer because they're afraid they're going to get hit with a bill, or they're going to try and get sold something that they don't need. And we thought it would be valuable to offer this free 15 minutes to hop on the phone with somebody, figure out what their issue is. Sometimes people don't need a lawyer, they need an accountant or an insurance provider. And the way that you can do it is just go to our website. There's a book a consultation button on the main page of the website. And one of the options on that booking site is a free 15 minutes. So I apologize to Naz and John if they're on the call, if you guys get blown up with 15-minute consults, but we're really excited to do that. It's we find that we can provide a lot of value in 15 minutes. So.
Yeah, that's amazing. And I do feel like most of us are afraid of speaking to lawyers. So that really helps. And I love, just to mention, I really love all the purpose behind macushlaw and everything you mentioned when I first met you and you explained how the office runs. I haven't personally heard of any firm running like that. So I really appreciate how you guys do business. And I hope there is more lawyers doing that. That's amazing.
Thank you. Yeah, we're proud of it. We're learning every day and sort of constantly taking notes and figuring out how we can do better. But we're only a year and a bit old here, and so far so good.
Amazing. Yeah. Thank you so much, James. I know you have another 7 p.m. So thank you for your time. And if anyone wants to talk to James, just head to macushlaw.ca. Is that correct?
That's correct. Yeah.
Yes. Perfect. So thank you. And I'll get Darryl in and Tia. Thank you so much.
Perfect. Okay.
Oops. Sorry. I think I got a little bit too soon. Hi, Darryl, Tia. Welcome.
Hi, Julia.
Hi. So I'm also super excited about you guys' topic today, talking about financial strategies to accelerate your growth. And minimize taxes. So you're both financial advisors. I'll let you introduce yourself, your certifications. I love that you guys are a couple for business and life. So I'll let you introduce yourself. And again, just remind to everyone, please put your questions in the chat, and we're going to have Q&A time in the end.
Sounds good. So yeah, I'm just sharing our screen. If you can post that up, we can get started. Okay, I think everybody can see the deck.
Yeah, I think so. So first off, we want to thank you, Julia, for putting this series of webinars together. So this is great information for all you business owners out there, and we really look forward to adding these sessions with ours on our financial planning. So like Julia said, there will be a Q&A at the end, but if you have any questions, you can type it in the chat and Julia will help us monitor this. So hi, everyone. My name is Tia Ho.
And I'm Darryl Ho, and our company is called Wealth Blueprint Strategies Incorporated. We are a husband and wife financial advisor team, and we specialize in helping business owners accelerate their corporate dollars and minimize taxes. So before we get into that, we're going to start off by sharing our story and why we're so passionate about what we do as financial advisors.
So here is our story. In the middle is a picture of our family. So that's me, Darryl, our son Ethan, who's 14 now, and our daughter Madeline, who's 12. And of course, also our two fur babies. The white one is Bentley, and the toy poodle is Peanut. And you know that they are the ones that rule the household. So this picture was taken this past summer, and I bet by next summer, I will probably be the shortest one because these kids are growing up way too fast. On the upper left, the black and white photo is actually me and Darryl. So Darryl and I actually met back in high school. This is a picture of us in grade 10 when we met and started dating. So that was 28
in January,
28 years coming up in January. So, but after high school, we both went to UBC. Darryl graduated as an engineer and I graduated as a teacher. And after graduation, we wanted to get married, but we couldn't. We were in debt. Darryl owed over $40,000 in student loans, and I owed about $17,000. So there was no way we could get married. This is when we really started thinking more about our finances and looking into how to save more money and actually grow it faster. So fast forward a few years, we were able to save up and get married and buy our first condo. But due to some issues in our building, we actually had to sell our condo in about 2 years. But when we sold it, we made $60,000. So 17 years ago, to save up $60,000 would have taken us like a number of years. And by selling the condo, we fast-tracked our savings. This is when we figured out that there was more to real estate than just buying and living in it. And unfortunately, we were only able to figure this out in our late 20s and not earlier because they don't teach finances in schools. And to this day, they still don't. So with smart planning and experience, we were able to acquire more properties, and now we have rental income added to our income. We also made smarter choices with investing our money. We realized it's not all about earning a high salary. It's really about making good choices with the money that you have. So we wish someone had told us all the options that we know now, and we wish someone was there to guide us in making smarter financial decisions. And this is how our company Wealth Blueprint Strategies started. We are now someone that can help you, and we can show you what works and what doesn't work. On the right side are just a few pictures from about just 2 years ago when we completed the build of our dream house. And we were so lucky that it finished just before COVID. And so we really got to enjoy the space last year.
And so when you kind of take a look at all this, we have experience in whatever life stages you're at. So whether you're in debt, buying your first condo, acquiring rental properties, building up investment portfolios, owning a business, or building a dream home, we've done it. So now we have an opportunity to share experiences with others so we can help them out. So as you know, experience is important, but equally important is you have to know what you're doing. On this next slide, here are some of my designations and licenses that I have. In BC alone, there was about 30,000 advisors. So what makes us stand out? Well, first of all, we're a husband and wife financial advisor team. So having Tia on board already sets us apart.
Yay!
On top of that is the knowledge we have acquired over the years. If you look in the middle, CFP, that stands for Certified Financial Planner. So I have that designation in addition to my CLU designation. In case you don't know what these are, this is how I explain it. Like whenever you go to a bank and you talk to any entry-level investment advisor or life insurance advisor, that's kind of getting the high school level degree. When you take on more courses and pass the level 1 exam, that's like getting your bachelor's degree. When you do even more courses and you pass the level 2 exam, that's when you get your CFP designation, and that's like getting a master's degree. And then after that, the PhD level is having a CLU designation. This is where the specialization is around advanced estate planning, advanced tax planning, and corporate planning. So I guess I'm a bit of a nerd when it comes to finances.
But you want a nerd when it comes to your finances, right? So it's good.
In the bottom middle, we also specialize in life insurance as well. I'm one of the few advisors in British Columbia that is an infinite banking concepts authorized practitioner. If you Google IBC, it's a way how you can structure life insurance policy so you can use it as a bank account. On the top right, I'm also a member of the $1 Million Roundtable, or MDRT for short. In case you don't know what that is, it's kind of similar to the Medallion Club in the real estate world, right? With the Medallion Club, that recognizes the top 10% of realtors local to the Greater Vancouver area. With MDRT, it's actually a global recognition and recognizes the top 10% of financial advisors in the world. So it's pretty cool to be achieving that. And then on the bottom right, I'm also a licensed mortgage advisor with Dominion Lending Centers since 2011. It's been just over 10 years. We do have a team of mortgage advisors though that we partnered up with. So, we do take the initial phone call, but anything that's mortgage related, we pass on the mortgage piece to our colleagues. When it comes to financial planning though, Tia and I, we're the only ones with our investment and insurance license on the team. So we do that end to end. So when it comes to finances, you can be confident we know a thing or two about finances. On the next slide, here are 6 components of our financial plan. When we put together your wealth blueprint, these are the 6 things we specialize in. So up at the top, cash flow planning, and that's really seeing where your money is at and making sure is it going in the right places. Next is tax planning, which is important for business owners. Right? When you start pulling money out of your corporation, right, how to keep more of that and less to taxes. On the bottom right is insurance planning. And this is one of the specializations where we know how to ensure your money and family is protected, especially inside a corporation. On the bottom is investment planning, pretty straightforward. That's just wealth management. This is essentially investing your money in the right portfolios and having your money make you more money. Then at some point, everyone retires. And what we do is helping you plan ahead to ensure you have enough for a comfortable retirement. And then at the end of the day, we all pass away. It's kind of sad, but it's something that happens to everybody. When we do pass on though, if there's still money in your corporation, it all comes out and is taxed. So what we do is make sure that we plan properly so that you're able to leave more money to your loved ones and less to your taxes. So the goal overall is to have each of these components as part of your overall wealth blueprint.
So let's first start off by looking at why we are business owners in the first place. So some of the reasons are we get to be our own boss. We get to make our own decisions about our business. We have flexible schedules, so we have control over our time, and it doesn't have to be 9 to 5. We have unlimited potential income. Usually, the harder we work, the more we make. One of the main reasons why we get incorporated is the low tax rate of 11% for the first $500,000. And ultimately, at the very end, we are business owners because we want to make a better life for ourselves and, of course, for our loved ones.
Yes. So the next slide, we'll talk about what we do not like about being as business owners. And that is, of course, taxes. Mm-hmm. Right? Whenever we draw income out of a company, whether you draw out a T4 or a dividend, we get taxed. When we grow money with investments inside a company, we get taxed. Right? Passive income tax inside a corporation is actually quite high. It's about 50.67%. So you end up giving more than half of your gains to your CRA. When and if we sell our businesses, we'll get taxed. Yes, there's the lifetime capital gains exemption, but in some cases, it doesn't actually apply. So therefore, there's a good chance you're going to get taxed. And then at the end of the day, like I mentioned earlier, when you eventually pass away, whatever money you didn't take out of a corporation, all of that is going to get taxed when your loved ones pull the rest of your money out.
So the question is, what do you do? Unfortunately, there is no one size fits all. It really depends on what your situation is. So are you married? Do you have kids? What are your goals? And what do you want in the very end? So everyone's story is different. So our focus in our initial meeting is to get to know you really well and see what your story is and where you want to be.
Yeah. And as he has mentioned, although there's no one size fits all, we have over 30 financial strategies. So we will have a solution for you. What we do next is we're going to share with you a couple of real life clients we have helped out. All right, this will give you an idea of what you can do with your money if you're in a similar situation. Of course, we change the names and the occupations for privacy. And with these next two scenarios, you're going to learn about 6 different financial strategies.
So we'll start with Kathy. So meet Kathy. Kathy owns a music school for the past 15 years. She has grown her business to 3 locations in Vancouver. She's 50 years old, she's married, and she has 2 kids. She owns a house, she has about $50,000 in savings, $150,000 in RSPs, and she's maxed out her TFSAs. So she wants to plan for retirement, and she wants to know how to best invest this money while minimizing taxes she pays. So she has about $50,000 per year to put away for the next 10 years. She also wants to make sure she passes most of this money to her kids because they are not interested in taking over the business. So Kathy came to us asking for options.
Yep. So how do we help Kathy? So here's a couple of solutions that we help to implement. So again, kind of summarizing, right? She wanted to put money away so that when she passes away, most of the money will go to her kids. So let's assume that she's going to pass away at age 85. She's 50 years old now. She's going to put $50,000 away for the next 10 years until she's 60, and then just let the money grow. And then at 85, she's going to pass away. So what are options? First is do nothing, right? Some people just hold cash. So if she put $50,000 a year over 10 years, her account's going to be about $500,000. Pretty straightforward. But because that money is in the corporation, as prior she feels that she's going to have $500,000 set aside, eventually when she passes away, all that money is going to come out and be taxed. So, ballpark, she's going to get roughly about $300,000 left to her kids only if she does nothing. What she can do, she can go to the bank. She can talk to an investment advisor, and somebody can say, hey, Kathy, come, give us $50,000 a year for 10 years. We're going to put into mutual funds. We're going to grow it at, a conservative rate of about 6% rate of return. And then when you do the math again, because she's investing money inside a corporation, every time she makes gains, just over half goes to CRA. So when she passes away at age 85 and then all that money comes out afterwards, she gets about $1.2 million. So that's not bad, better than doing nothing. However, the third thing with a wealth blueprint plan, right? Since she was talking about estate planning, one of the best assets to acquire inside her company is a corporate-owned whole life insurance policy. And what we did is we contributed $50,000 a year for the next 10 years. When she passes away, majority of the death benefit actually comes out tax-free. She would be passing about $2.5 million to her kids, and that's double what a typical investment advisor would do. What we also did was we implemented an investment loan strategy. This allowed her to take about $10,000 per year from her company, pay 0 taxes on it, and then have about $300,000 invested and grown personally. So again, instead of investing $10,000 a year inside a company and losing half of it to gains, we're able to take that $10,000 out of her corporate dollars out per year, pay no tax on it, and then she had a $300,000 asset growing for her. So when you kind of take a look at this, with our wealth blueprint plan, Kathy is going to be passing away $1.7 million more to her kids than just typically going to the bank.
Okay, so let's go to our next story, and we'll teach you a few more strategies. So this is Jag. So meet Jag. Jag is 40 years old, and he's a chiropractor earning about $300,000 per year. So he's married to Nisha, who's 47 years old, and she works as a daycare teacher earning $50,000 per year. They have no kids, and they do not plan to have any. All their accounts are with their bank, earning only 5% return. They don't know much about investing, and their bank advisor keeps changing on them. So they want to know how to best invest their money and ensure they have an abundant retirement. They plan to do lots of traveling, but they were worried that they weren't doing enough. And their parents just keep telling them to pay down their mortgage and be mortgage free.
So here's what we did with Jag. Right. Since Jag and Nisha have no kids, they plan to travel the world when they retire. They actually said they wanted at least $100,000 a year. True story, right? Most of the people, they allocate maybe $5,000, $10,000 a year, maybe $20,000 max for traveling. But for them, they wanted to travel 6 months at a time, and they felt they needed to put away about $2,000 per week in order to do that. Without her help, they weren't going to make it. So we had to implement different ways to make them more money, but minimize taxes on the gains. So here were our solutions. We educated them about the attribution rule. Since Nisha made less money and is in a lower tax bracket compared to Jag, he originally thought he can give money to Nisha to invest and then have the gains taxed under her tax bracket, right? If they do that wrong, the gains will actually go back to Jag. That's called the attribution rule. So to get around that, there's a couple ways, right? We had Jag contribute towards a spousal RSP under Nisha's name. Jag gets to use his RSP room to save on taxes, and then the money goes to Nisha's spousal RSP. As long as she takes the money out in about 3 years, it'll be taxed under her tax bracket and not Jag. We also had Jag contribute to Nisha's TFSAs. Right? Any growth won't get taxed, even though Jag gave her money towards the TFSA. The next thing we did was we moved over all the investment accounts over, RSPs, TFSAs, etc. Given that they were saving for retirement, a 5% rate of return at the bank was far too low for long-term investing. Our average rate of return with our clients is about 8 to 12%, and that's where everybody should be if your timeline is 3 to 5 years or longer. Some tax planning was done. There was actually a handful of things done here, but just sharing with you, one of the things that we did was we actually talked to Nisha and suggested her to start taking out some of her individual RSPs, even though she was only 47 years old. Right? From a tax planning perspective, for Nisha, whether she makes $50,000 or $84,000, that's the same tax bracket, and it's around 28%. So this is one of the bottom 3 tax brackets in BC. Since we can control the taxes now, we took out some, and then we invested the money into TFSAs so that future growth is tax-free. One other thing we did was that's not conventional is we refinanced a mortgage back to 30 years and also added on a HELOC, which is a home equity line of credit. Right. This meant that their parents told them to pay down their mortgage and be mortgage-free. It was actually wrong advice. I told them that paying down the mortgage faster doesn't make your house go up any higher in value. So all you do is you lock up money into the 4 walls. And right now, with variable rates around 1.5%, borrowing is super cheap. Right? If the investments are making 8 to 12%, and they had, say, extra $10,000 to put somewhere, it makes no sense to pay down a 1.5% mortgage when they can earn multiple times more if they invested elsewhere. Also, they have no kids, and they said they don't really have any plans of giving the money to anybody. So instead of locking all the money up in the home, we restructured the mortgage to free up additional cash flow to invest and build a bigger retirement fund. The HELOC was added as a way to access equity in their homes. So rather than sell and downsize in the future, they can use the equity in the home to fund their retirement. So if I kind of pause here, overall, we actually did more for Jag and Nisha, but we wanted to just highlight a few strategies in today's session. Before we wrap up, let me kind of recap what we just went over. Right? We shared with you about half a dozen financial strategies to help business owners accelerate their wealth and save on taxes. With Kathy, we talked about corporate-owned whole life insurance and investment loan strategy, right? And then with Jag and Nisha, we talked about how to income split the right way so we avoid the attribution rule. We talked about how portfolio management services is very important so that your money grows in the 8 to 12% range. We implement tax planning strategies so that you can pay less taxes. And we even talked about restructuring a mortgage. Right? Most other advisors don't know how to use your home as a retirement planning tool, but we do.
So we hope you can see the value of having a certified financial planner as part of your financial team. As business owners, you need a plan. So you need to make your stagnant money in the business work for you. You need to grow the money in your company without the passive income tax. And you need to ensure more of your hard-earned money is passed down to your loved ones. And you need a trusted and committed team behind you. So hopefully that can be us. And yeah.
Any questions?
And then one quick note, we are licensed in BC, Alberta, and recently in Ontario as well. So this is all thanks to Zoom.
And one last thing, I'll offer to you this evening is a 1-hour session to do a financial health check. Right? Normally, we do have a minimum of about $250,000 in investable assets, but because you invested your time tonight listening to us, whether it's live or watching the recording, we want to thank you and give back our time to you. And make sure we point you in the right direction. So no minimum for you guys. Just send us an email and let us know you attended BusinessPalooza, and we will connect.
So yeah, we're done, and we'll pass it back to you, Julia.
Thank you so much, guys. I love all of this. I'm going to leave your slide here just for another second. If you guys want to screenshot, grab their information and take advantage. I want to have this 1 hour financial health. I'm going to reach out to you guys. Love this, love all the examples. I think the more I learn about like business accounting and financial planning, like the more I learn, the more I see that I know nothing about, and I should just work with people who do, because we don't, right? Like we don't study these things in school. Like we just don't know how to do things and how to be smart about taxes and things like that. So I was planning to purchase a car, which I just did this weekend, my first car. It's kind of funny, but anyway, that's another story. But I was like, should I pay cash? Should I finance? Like I had the money to pay cash, but I wasn't sure what to do. And then I was hearing all the suggestions of like in strategies to, for example, finance at 0 or 1% and leave the rest of the money growing in an investment, and then just remove like the monthly payments. And this is just something like that I would never think on my own. And just hearing someone telling me that, I'm like, that makes so much sense, but I just didn't think about it. So definitely helps to have someone who knows this stuff and like to go in. And as you said, each situation is unique. So you're going to see like, are you married? Do you have kids? What are your goals? To really make a strategy that it's tailored to that person, to that situation. So I really see a lot of value in this. Thank you.
Great, thank you. Yeah, for sure. It's just about the numbers, right? So Darryl loves numbers. He loves spreadsheets.
Numbers don't lie. That's why.
So yeah, he can definitely tell you what is the best option. Yeah.
Yeah. Yeah, perfect. I don't see any questions. I see some comments like, love the case studies. Thank you. So I think that's it for tonight, for day 2, for this week. So anyone, like if you guys want to work with any of the people that you're hearing from the series, please feel free to reach out. I'm going to send a follow-up email with the recording if you want to watch from the beginning or rewatch, because there was so much information, and a link so you can connect directly with the speakers. So thank you again. Have a great night and chat soon. Have a good long weekend. And yeah.
Yes.
Great. Wonderful.
Yeah.
Thanks for tuning in, everybody.
Thank you. Bye.